Next to offer arguments was Ms. Zoe Jacoby, Assistant to the Solicitor General. She was representing the Department of Justice, who agreed with the petitioner's position.
Mr. Chief Justice, and may it please the Court, the Fifth Circuit analyzed this case by examining only the so-called moment of the threat and categorically ignoring all prior events. None of the parties defends that approach. That is because reasonableness is assessed under the totality of the circumstances, and pre-force events can be critical to that assessment. Prior events often show that the force was reasonable. For example, police may have issued warnings or attempted de-escalation, all of which a split-second moment of the threat doctrine misses. Of course, when officers face a moment of danger, that is by far the most important factor under Graham. But in rare cases, a moment of danger doesn't tell the whole story. If the danger was manufactured entirely by police conduct outside the bounds of reasonable behavior and not by the suspect's intervening apparent misconduct, it is unreasonable to use force in the moment. The panel's approach fails to provide a constitutional backstop in those cases, and it disregards context that may show that force was reasonable in others. I welcome the Court's questions.
I think Ms. Jacoby's argument is both succinct and convincing. Yes, what happens before the moment of threat puts the threat in context. Did the officer escalate or de-escalate the situation? Was it the actions of the accused or of the officer who initiated the moment of danger? Were the actions of law enforcement reasonable or not? This is what needs to be considered when determining the reasonableness of the actions of law enforcement.